Let's get back to our top story. The Supreme Court wrapping up day one of a challenge to President Obama's health care law moments ago. At issue, whether the government has the right to require you as an American to buy health insurance. The High Court is expected to hand down a ruling in late June on a controversy that is already a key issue in the presidential campaign. So what can we expect? With us now, constitutional law attorney and former White House counsel under Presidents Reagan and George H.W. Bush, David Rivkin. He also represented the 26 states challenging the law in the lower courts. You're at the Supreme Court because that argument didn't go so well for you, right? So what are you expecting these justices to say?
No, we're actually before the Supreme Court because the argument below went very well for us. We won both at the District Court and 11th Circuit.
All right. So, but the government is arguing that the individual mandate is constitutional. To that, you say what?
We say that this is an unprecedented use of government's power, that it's inconsistent with the key feature of our constitutional architecture, that the federal government is supposed to exercise limited and enumerated powers that regulate things and activities and not individuals directly. Only states can do that, and the 200-plus years of case law support us. So I'm extremely optimistic we're going to prevail, and the government is going to lose.
So when Democrats, for instance, say that they patterned this law after what Mitt Romney did in Massachusetts and that he is the godfather or the grandfather of Obamacare, and they have said that, what do you say? What's your answer to that?
Well, the two answers. One is, as a matter of policy, what Massachusetts did is very different than Obamacare, but that's a policy issue. As a constitutional matter, what they're saying reveals the utter ignorance about our constitutional architecture. States in our constitutional system are allowed to exercise general police power, the ability to regulate individuals simply because they exist. Thus, a number of Gulf states require people to purchase hurricane insurance. Massachusetts required people to purchase medical insurance. Virtually all states require to have car insurance as a condition of driving. But that's for the states. The federal government does not have this power. And again, the fact that they don't appreciate the difference between the power that's vested in the states and the power that's vested in the federal government just reveals to me utter constitutional ignorance. By the way, the framers, John, did this. They diffused power to protect individual liberty. They did not want the federal government to amass in its hands all the power in the land.
But there are observers who say that even some of the most conservative justices on the court have been receptive to arguments involving the Commerce Clause and allowing the Commerce Clause to give the federal government very broad power.
That is absolutely true. What they're missing, though, is that all of our justices in the court and the entire court's jurisprudence, while supporting very broad use of Commerce Clause, has consistently emphasized that it's not unlimited. The problem with the individual mandate is that it cannot be supported by even broadest application of a Commerce Clause. It can only be supported by general police power, which I just mentioned only the states have. And again, the difference is very simple. Commerce Clause allows you to regulate things, activities, instrumentalities, tangible objects, and you reach people only insofar as and to the extent that they are involved with those things. General police power allows you to reach people directly. This mandate regulates people directly because they exist, from cradle to grave.
So
that's not the Commerce Clause.
If the individual mandate is struck down by this high court, do you think the entire Affordable Care Act goes away?
We're hopeful that the entire statute would go down. The individual mandate, as the government itself has acknowledged repeatedly, is at the heart of the statute. It particularly tightly connected with the reforms, so-called reforms of the insurance industry. It's connected very intimately with the restructuring of Medicaid. It's another problem we have. So we believe it's a statute that has to come down if the individual mandate comes down.
David Rivkin, a constitutional law professor, attorney, I should say. It's good to have you on. Thank you.
Pleasure.